for the scan copy with present status, Lordship. Learned PP had checked them.
As per office note 412, is awaited, present status is awaited.
It's from Amingao, Lordship.
18th of
January.
You want in January?
First week of January, madam.
First week of January. 9th.
Lordship.
May I please?
Deep level.
Lordship, this bail application file yesterday, my lord. The urgency, my lord, matter may be taken up tomorrow, my lord.
What is the urgency?
Urgency, my lord, because it is land dispute matter.
When the FIR was launched.
And dispute arise, my lord, LS in the year 2021. Now FIR laws recently.
When the FIR was launched?
FIR laws was 15 of 11, 15/11. So tomorrow, tomorrow.
Okay, tomorrow.
May please your lordship. Lordship, regular bail application filed on 3rd, my lord. My lord may be listed on Monday and behind for month. Deeply obligement.
May please your lordship, the item number 34, lordship. Submitted, lordship.
34. Just wait for a few minutes. We'll pass the order as soon as the mention is.
Lordship, and another matter for listing regular bail application yesterday file, lordship.
Monday. Yes.
Please, your lordship. Item number 64. In the NDPS bailiwick, there is no interim order. For take up matter 2 years, earlier it was left over.
CBM.
On CBI, I will inform you.
No, let Mr. Hal will be here. Okay.
I'll inform them. At 2 years.
You do not know. We'll consider your prayer. The 11 point.
Okay, so earlier it was.
May I plead, your lordship? Item 16 of today's list, your lordship. The matter has been wrongly listed. Section 304B is there, your lordship. Matter may be listed before appropriate bench, your lordship.
Registry shall verify and shall list the matter before the appropriate bench.
Tomorrow, your lordship. Tomorrow?
We cannot give the date. You ask the registry, they will do it.
Oblige, your lordship.
May it please your lordship, I beg to mention item number 44, lordship. This matter has been infectious, lordship. Petitioner was arrested, lordship. AP, lordship.
What's your good name?
M. Alam, lordship.
Main part. Then the main part. The police case to sign.
Lordship, may I plead, your lordship? Similar prayer for item number 19. It has become in process. The petitioner has been arrested.
19, no? Same. Case number 5.
CBI.
Oh.
Item number 20, pass over for the day. We have to take instructions. Same PS, lordship. Pass over for the day.
Okay.
Deeply obliged.
Monday.
May I please, your lordship? Item number 22 and 23, my lord. Kindly adjourn for 2 weeks, my lord. After vacation, my lord, we will take January 2nd week.
After Bihu. 20th. 20.
Yeah, please, your lordship. Make a mention for a IA. It was listed, last listed on 10/5/24. It relates to lordship vacation of a stay order. We have filed that. Lordship, may I pray that it be listed on 12th or 11th of this month? If it is not inconvenient.
11-12 board is full.
13th, lordship. Any day as per the lordship's.
13th.
So, nice.
May I please, your lordship?
Yes.
I beg to mention for withdrawal, my lord, tomorrow, my lord, kindly, my lord. 2 matters, my lord. And another prayer, my lord, item 15, my lord. I want to withdraw, my lord, as per instruction, my lord. Item
The
15.
prayer of Mr. J. Ali, right?
S.I. Sikdar, my lord.
As it says. Yes.
I love
My please, your lordship, my prayer for listing tomorrow a regular bail application, your lordship, for motion, your lordship. Already on case out of same case that your lordship already listed. Item 30 before this honorable court, your lordship.
Okay.
Tomorrow. Oblige.
May it please, lordship, I beg to mention item number 24, 25, and 26. Lordship, as per instruction of my senior, kindly matter may be adjourned for a week.
It will come after vacation. When do you want? Tell us.
18th.
Okay, on 18th.
May it please, your lordship. Lordship, I beg to mention for listing of a bail application, my lord, for motion, my lord. Tomorrow on the ground date, my lord, the main accused has been granted bail by your lordship on 27/11 in bail application 3525, my lord. Therefore, we are seeking similar,
It's a
my lord.
pre-arrest bail or
No, my lord, regular bail, my lord. He is behind bar. Obliged, ma'am.
May I please, your lordship, I beg to mention for listing one IA criminal number 1200/24 in BA number 3516, lordship, on tomorrow, lordship.
not tomorrow? For what? Why tomorrow?
Lordship, for recalling of bail order dated 25/11.
Monday. Monday. Yes, ma'am.
May I please, your lordship? Lordship, I beg to mention item number 21. Your lordship may kindly adjourn this matter for a week.
After vacation,
Obliged, your lordship.
8 January.
May I please, lordship? My lordship, I beg to mention for a listing for order, it's a criminal revision petition.
11.
Obliged.
May I please, your lordship, I beg to mention item number 18, my lord. Matter may be passed out for the day. 18. 1/8.
Next week. Monday. Yes.
May I please, your lordship, my lord, I beg to item number 46, my lord. I may be permitted to withdraw this petition, discuss, my lord, as an instructed by the party, my lord.
Dr. B. Hussain. Mohammed Bin. Okay.
Last.
Regarding item number 40, my lord, last occasion, appeal CD was called, but today not available affidavit CD, my lord.
Even,
40 item.
yes, my lord, updated 3 not received, my lord. It's updated, yes, last order of 13/11. CD we received 12/11, my lord.
Send back.
It is not taken back, my lord. Send signal.
Have it on 17.
My lord, maybe after.
After vacation, my lord, this is an interim, my lord.
9th.
We are on interim, my lord, maybe continue, my lord. Like another submission with the regarding item number 29, my lord, may be taken after vacation, my lord.
29.
When do you want?
29, my lord.
After vacation? It's more lamba se putta ke. 21st of January.
May I please, your lordship, lordship, prayer for listing IA in criminal appeal, lordship, some urgency is there.
Monday.
Monday, obliged.
Sheet number 21/24. And then 21B NDPS dated 30/11/24.
है ना? ठीक है? Next.
Lordship, this is a bail application, Lordship, under section 480 of BNNS. The accused is in jail, Lordship, from 17/10/2024. He was arrested on the basis of the FIR lodged by the victim's mother.
Yes, ma'am, can you take steps on the public
Lordship.
prosecutor to be registered during the course of the day? This
Lordship,
is from
notice will
Paltan
be,
Bazar. You have to take steps
Lordship,
on the informant respondent number 2.
Lordship.
Mr. Parasar from Paltan Bazar.
CD, my lord, 18, my lord.
Okay, 19th. Take steps during the course of the day.
Lordship. Obliged, Lordship.
May I please, your lordship? Regular bail application, petitioner was arrested on 26/11. FIR is at page 12.
And morality. When, which date?
Bohisto. 17.
May it please, your lordship. Regular bail application, lordship, petitioner was arrested on 10/11, lordship. Today is 25 days, lordship. NDPS, lordship. 21.
Lalu.
Lordship.
Lalu, my lord. 19, my lord.
19. Highly obliged.
Lord, charge sheet case, my lord. Lord, almost, my lord, 9 months behind the car, my lord. Commercial committee call for the scan copy of the case record. And,
Special NDPS Beckezer device, case number 32/2024. Arising out of Bazilisera Police Station, case number 47 of 20. Calamity eligible. Calamity copy of the case.
my lord, may I allow to correct a single alphabet, my lord? The petition number 2, my lord. It would dissolve V, but written at V, my lord.
Corrected with your initiative.
My
We'll
lord.
have it after reopening. That will be
Obliged.
7th of January.
Obliged.
He has
May I
on
please,
his-
Lordship? Lordship, in this case, I am not acting
Just a
accused,
minute.
Lordship.
Sonapur,
Yes, my lord. Even gang others maybe behind the bar. On
Lord.
17, my lord.
Obliged, Lordship.
Meet with your lord. Sir, this is first seated matter, my lord. First seated under section 6 of POCSO, my lord.
special Preliminary POCSO. Case number 323 of 2024. Arising out of Gauripur case number 106. 232. Take steps on the informant respond number 2.
My lord.
From the court of special
Special
judge POCSO. Communication session there.
By
8th of January. Has been 19th December.
19.
We'll have it on 8th of January.
My lord. Highly obliged.
Yeah, Mr. Malad, this matter may be taken along with the item number 36, because in that case, same CD, my lord, same case number, same.
You have written 48 years.
48, yes, ma'am.
Item 48.
36.
48, my lord, same.
Okay, we'll take it up together.
Yes.
Yes.
Lordship, the petitioner was arrested on 14/3/24, Lordship. By this time, the charge sheet has been laid, Lordship. But the alleged contraband is not recovered from the present petitioner, Lordship. Lordship, will kindly have a look at page 17.
Mr. Parashar will tell us, give us a
It's
we'll get it
from
from
additional sessions as Guwahati, Lordship.
NDPS case number 325/2024. Arising out of Guwahati GRPS case number 74/202.
17.
Don't think so, it will come by that time. Today is 5th. Right on 19th, if possible.
Lots. Participate the LCR
The,
report.
along copy of the area of Guwahati Jail. Right, no? Can let it be. Okay.
I'm all right.
May I please, Your Lordship? Lordship, regular bail application, my Lordship. Offense under section 303, 317 and reduced section 53, 1A of
Yes,
excess.
Mr. Parashar,
My lord.
excise case
Lordship,
from Bishnath Sarili when
Vishwanath Savili, my lord, will try, my lord, by 18. Otherwise,
completed.
18.
May I please, Your Lordship? Intermediate quantity, Lordship, cash day may be called for and matter may be fixed on 20th of December, Lordship. On 20th, Lordship. Today is 27 days, Lordship. On 20th, Lordship.
from Pulibor,
Yeah.
arrested on 9/11.
9/11.
Right from 18, 19, whenever you get.
20.
Obliged, deeply obliged, my lord.
May I receive? My lord, the FIR is at page number 8, my lord. Petitioner is not named in the FIR. Once Saiful Islam was suspected, he is arrested, my lord, and the petitioner's name is nowhere, my lord. So he is not involved, my lord. And my lord is just trying, my lord. It is stated just trying.
Mr. Parashar from
Armsec, my
Sutia.
lord, Sotia. We'll try, my
Sotia
lord,
Bishop.
19, my lord.
And his short date,
19, my lord.
Okay.
obliged.
May please, Your Lordship. Lordship, FIR page 17, the very long FIR, my lord, so many allegations, my lord. Registered under section 498A, 420, 376, 511, 34. My lord, the case is that there was, marriage was served with the informant and the case number 1, who is serving as assistant teacher in a higher secondary school, my lord. In the month of April, the informant went to his father's house and thereafter she is not coming, despite of repeated approach by the petitioner. So petitioner has sent a pleader notice, that is page 28. my lord. After getting notice, the FIR has been lodged.
Manik Sil to Kuna, Mihir to Kuna, Mihir.
Last occasion, my lord got some status report.
Same case diary, same as I have read earlier.
My lord, even another 2 cases also filed against us, that is page 33.
No. Bail application.
Bail application, my lord.
Somebody has moved.
Other person, file person.
No,
Definitely. We have read this.
there should be petitions, my lord. 2 are brothers.
Manas Mihir and Manik Chandra file person. Pending.
Probably, no, there is. I read this, that's why I'm saying.
I have appeared last occasion, my lord.
In which item?
On
For whom you have appeared?
both petitioners.
What happened? You do or what?
My lord, in that, my lord sought some status report.
Then why you have filed the second bail application?
I'm not saying, I'm with only this.
No, that case, another case, or what?
No, this case only.
In this case only, that's why I'm reading it.
Oh, my lord, it is, yes, it is fixed. Today is second day.
Today is fixed, my lord.
Second day, my lord, 27 day. Status report. That's all.
Since it is from,
My lord, I'll take instruction, madam.
Get it?
We have sent the signal on 28 itself, that's not the case. I think you have to do it. After some time, my lord, will, or at two, my lord. I'm.
May it please your lordship, this is an anticipated bail application, my lord. FIR is at page number 11, my lord. Case is registered under section 4 of the POCSO Act, my lord. What happened was that, my lord, the petitioner and the victim, my lord, they were in some relationship, my lord, and my lord, she was pressurizing the
Charge sheet has been filed and as on this, only 3 witnesses has been cross-examined. And none of the witnesses has stated the name of the present petition. And lordship, in this case, I have been shown arrested in this case. And I was arrested on 18/12/2023.
Take your seat.
What's your good name?
Jacob Mia.
Heard Mr. Jacob, counsel appearing for the petition. And M. Decker, learned counsel on behalf of the Special Public Prosecutor. NCP. Respondent NCP. That's it. Yeah. Very important. Name 24 of the NDPS arising pending. In which on receipt of specific input from reliable source that one person, namely Muhammad Sabir CTI, resident of Bihar, would be carrying huge quantity of ganja from Tripura to Bihar in a motor vehicle. The NCB officials look for and a container truck bearing number NL 01AA 5344 at Kanapara area, NH 37 near Hill City Hospital around 3:30 p.m. After reducing the sale information in right, I got apprehended the apprehended container at 3:40 p.m. The NCB personnel stopped the safe vehicle and after the inquiry from the driver of the safe vehicle, he failed to produce documents stating that those are which one Shah Jahan, who handed over the truck to him and that he would follow to the documents dowry. During such search, in presence of independent witness. And the said driver Muhammad Sabir six hundred and 82.2 kgs of ganja was recovered that was kept concealed inside the said container truck bearing registration number. Inside a false cavity on the cabin roof, on its cabin roof, which was removed by cutter. Said Sabir was the prodigal, taken into custody. According to the petitioner, he is no way connected with the case, and just for payment of rupees 2,000 to Said Muhammad Sabir, he has been arrested in the case on 18/12/2023 and in custody since then. Considering the period of his detention since 18/12/2023, the petitioner has prayed for. Here is the records of said NDPS case number 151/2023 arising out of NCP crime number 0723 that was called for by order dated 06/08/2022. Record reveals that said ganja was recovered and seized in presence of independent witnesses by following the same procedure. Inventory was also prepared following the provisions of the NDPS and the rules. And after obtaining samples in presence of the learned magistrate that were forwarded to the FSL Guwahati before the judicial matrix for its chemical examination. The FSL report dated 18/7/2023 have found that the seized items in the said such and such classification gave positive test for cannabinoids CANNABNOIDS and CANNABINOLS, including THC. From the case records, it is seen that the petitioner hailed the arrested driver, Muhammad Sabir, alias Muhammad Sabir SHABIR, during his stay at Agartala, and also followed him to Guwahati while the said arrested driver of the vehicle was driving the said vehicle from Agartala to Punjab. The report reveals the presence of the petitioner following the truck involved in the case to the CDR details. Report also indicates that he is the supplier of the seized ganja and was and through the seized truck it was carried to Bihar. In that regard, the arrested accused persons of the case in their statements also indicated the involvement of the petitioner. That is what is called that's called in their voluntary statements. Though the NCB personnel from Kolkata visited the residential address of the petitioner, it was found locked and came to know from the neighbors that for the last 2 months he was not available there, and later through his and later during investigation the NCB officials found his presence at Agartala. Who during the stay of the driver of the said vehicle, Muhammad Sabit, used to fund him in cash and also in his account which the driver concerned withdrew by ATM. In the case record also it is seen that after filing of the charge sheet in the case, under section 20, put in bracket small b, put in bracket small 1, 2, put in bracket capital section 29, the NDPS Act. On 27/05/2024, London Trial Court, High Court of London Special Judge NDPS, have recorded the evidence of 3 prosecution witnesses so far. Mr. Bhuya, can you tell us what is the status after August 2024? How many witnesses have been?
Only 3 witnesses has been prosecuted.
Yeah.
3 witnesses have been examined out of 8 lawsuits. 3 witnesses have been examined out of 8 lawsuits.
Out of 8 prosecution witnesses named in the search. What is the next date, Ms. Dekha?
Lordship 17/12/24.
Ms. Dekha, counsel appearing for the NCP. Submitted. And that 17/12/2024 is the next date for recording of evidence of prosecution. considering such periods in the case report pertaining to involvement of the petitioner, said NCB crime to NDPS case number arising out of NDPS, and finding that the trial of the case has already commenced and 3 witnesses, prosecution witnesses out of 8 where the next step for recording of evidence. The court is of the view that detention of the petitioner cannot be considered according to this bill application of Emily inside NDPS case arising out of NCB crime. अभी तो आगे मारी ले जाए
Yes, please do.
आगे मारी को क्या दिया मर्जी को
Here, your lordship, on last occasion, your lordship, the sanction order was not furnished before the learned court below. And on last occasion also, your lordship, it was not furnished, it was fixed on 2012, your lordship, for furnishing of his detention order.
He is in custody since when?
Since 7/4/2023, your lordship.
My lord, earlier, my lord observed that my lord, sanction order was not produced. If not produced by 28/11 was the date. But it is, my lord, in the record, my lord, there is nothing, my lord.
I have obtained the certificate copy of the last order.
But order was passed on 28/11.
Your lordship, let us check. It was fixed on 20 for furnishing of that copy of the sanction order.
Again.
We'll do one thing. 8th of January. We'll consider immediately after opening. Court is opening on 3rd too, but we have it on 8th.
Otherwise, your
He fails on this next date. Because without that, they cannot proceed in the
lordship. In fact, your lordship, if I am allowed to point out, your lordship.
document that was somewhere in the earlier occasion, we found that it was missing somewhere.
Yes, your lordship.
One date 6 of something, if I'm not wrong. 6 December or something was there earlier.
Now, your lordship, will once sanction order will be submitted, then they will have to take cognizance first, the learned court
Many
below.
things are there.
Then your lordship. Now, your lordship, in the meanwhile, your lordship, for more than.
The thing is this, by the time the next date, thereafter, we do not have the court. That's why we have it on 8th. Let us see, or if you want, we can have it on 3rd or 6th, 7th, any day.
Lordship. On 3rd, your lordship.
On 3rd, reopening.
Lordship.
Instead of reopening, we do not know that let it be on 6th.
Lordship.
Okay?
Yes.
Mr. Parashar, my last son. Take back your 45 so far.
Obliged.
The Parashar, if you read the recent judgments of the apex court, you will see not even an hour to that extent it has lost. You cannot kill a person like this.
Yes, this matter relates to NDPS case. The petitioner was arrested on interception by the NCD.
Yes, madam. In custody since 11/4/2021. How many prosecution witnesses are there?
Lordship, allow me some time. I will go through the record, Lordship. I could not check record, Lordship.
3 years and 8 months running, Your Lordship. And only one witness has been completely examined and two others are partly examined, Your Lordship.
As of now, 3 witnesses have been examined.
Two are partly examined and one is completely examined. The QW2 is completely examined, Your Lordship, and the position has been annexed here in as page 55. The cross-exam is part is here. That may be kindly go through it. But that is a admitted fact that the substances, whatever was inside the truck, was not identifiable. Whether that is a contraband drugs or something like that, contraband substance or some natural rubber seat. This is a member of the team, Lordship. He has admitted in the cross-examination that way. Petitioner was the driver of the truck.
What is the total quantity seized?
As allegedly 411 kg.
What is the next date?
Next date is fixed on in January. 19. 28/1/2020.
Just you said 12,
28/1/2025.
next date,
Next day.
Yes, Lord.
28th of August,
No, it's January.
January. I think we should take up this matter because certain things are there which you have found in the record. There's also evidence of the other three witnesses.
Even in last occasion also, it was found that the prosecutor has failed to take steps for calling up the witnesses. This is the order.
We have the orders. Let us just. Where is the arrest memo, Mr. Bowman? You have a copy of the arrest memo?
Perhaps I have not annexed to it, I'm not sure. This entire offense report is there, that is why.
No, offense report is there. When he was arrested.
He was arrested on 10/4/2021.
Ms. Becca, as per my calculation, the learned session judge has seen it on 181 days. Calculate. He was arrested on 10th of April. If it is 10th of April, then on 17/2021, it is 181 days. Calculate. From 10th of April. 21 days in April, 31 days in May, 30 days in June. Go on, calculate. 31 days in July, 31 days in August, 30 days in September. On 181st day, it was shown today. That is why arrest memo we need. You calculated? How much? You not calculated. You have a calculator. They are giving you the date.
I'm unable to.
You are doing it by hand, doesn't matter.
Calendar is there.
Yeah.
Calendar.
You add, go on edit. I have already added, find out. April 20, May 31, June 30, July 31, August 31, September 30, October 7.
Calculator में control.
So on 7th of October, it is 181 days. What will happen? That is why in the search sheet you have said in judicial custody from 11th. But when he was arrested, ask Mr. Well, Monday, or give us the arrest memo.
Highly good.
Allegedly, my lord, commercial quantity involved in this case. My lord. Arrested on 15/11. 15/11/23. As on date, 1 year, 20 days.
What is the total quantity?
Charge frame on April, my lord, your lordship will find charge frame order. Page 31. Page 31, charge frame under section 21C and 29. My lord, got it, my lord, on 18th April. Thereafter, my lord, on 6th June, 2 witnesses. Only they are the only independent witness. 11 altogether, 11 witnesses cited in the charge sheet. Apart from these two, one and PW1 and PW2, all others are official witnesses. So PW1 and PW2 were examined on 6th June 24. And thereafter, my lord, the informant, he was
His examination in chief was recorded on 13th August 24. But thereafter, my lord, your lordship will find cross reserve
Reserved by whom?
by prosecution.
Cross reserved by prosecution.
Here it is written at the prayer of defense.
Hmm.
But my instruction was on that particular day, prosecution,
When it was then.
whatever may be, my lord, thereafter, as on today was the date fix event. Today also no cross held. It
No
is
cross
again
by whom?
deferred.
No cross by whom? No cross by the prosecution or no cross by the defense?
No, because in absence of, my information is that in absence of the learned counsel for the prosecution, cross was reserved because he was not present. And today, thereafter 2-3 days, he did not turn up.
Possibility is there. Yesterday, his lordship visited Tipu. So being in the presence of Chief Justice, as you know, the judicial officers and other persons, possibility is there. For that we can understand. Today, of course, we do not know.
Thereafter, some other dates were given, but the inspector did not turn up. Today was date fixed. My latest information, just few minute before my junior has rang to the conducting council that today also inspector did not turn up and matter again deferred. So this is one of the aspect, my lord.
No, it is because of the non-availability of the witness or for what purpose?
No, the Supreme Court says in absence of, my lord, Supreme Court letter judgment, my lord, is already High Court has notified this judgment. The liberty has been given to the presiding officer to engage amicus curiae. So this is there. But here, my lord, on that day, though it is written, but my information is that that is there one day.
It cannot go beyond the defense, right?
But that was not done. But subsequent date, he did not turn. Other also not. Here, my lord, the case is that the vehicle is XEB 500. My lord, kindly note this. The vehicle is XEB 500. And LS contraband was recovered from the spare tire of the vehicle. And my lord is well aware, in XEB vehicle, a spare tire is only fitted outside in the back side of the vehicle. And I am a passenger. In paragraph 8 of my petition, my lord, I have stated the detail in respect of my defense. My lord, may kindly peruse paragraph 8 of my petition, page 5. So I am a passenger. Paragraph 8, my lord. Page 5. This statement, my lord. What? 61 years. And I am, my lord, 61 years of age. And that apart, my lord, may I continue submitting, my lord?
Yes, please.
the list. একশো কত বলতো? ওদের কেন থাকবো 100 The contraband was suspected at the time of seizing the morphine, and FSL give the positive test of divine. My lord, kindly consider page 23, their list of the total witnesses given. Here, except 3 and 4, they were examined already. The all others are official witness. Page 23. Altogether, 11 witnesses cited here. Now, the
What is the vehicle seized, you say?
XUV 500.
XUV 500. XUV 500, what we're also seeing in the computer and the other photographs, doesn't have a spare tire on the backside.
XUV 500.
XUV 500, right?
Right. XUV 500, FWD8, FWDW8 car. White color, page 28 description is given at the bottom. Last but 2-3 lines. That close column 5, Roman 5. XUV 500. And it got it. The co-accused, he is the owner and the driver. Owner come driver. Now, my lord, my second limb of argument, my lord. Only the two witnesses as independent, they were cited, and they deposed that the seizures were not made in front of them. They are specific evidence, my lord. Your lordship, kindly for a moment, peruse the evidence of PW 1 and 2. May I lead to your lordship to page 31.
We have the evidence before us.
Page 32, my lord. I have annexed page 32 of my petition. Cross-examination, page 33. My lord, got it.
Yes, please proceed.
Police personnel called me to sign the seizure list. I have not read the content of the seizure list. I have not seen the powdery substance. I was informed by police personnel that the powdery substance was brown in color, which they suspected to be heroin. I had not gone near the XUV 500 vehicle when it was searched. I do not remember the date of the incident. I am not able to recognize the accused Akum Chang today. The petitioner, he was present, but this independent witness did not recognize him. So from his evidence, then your lordship kindly turn to page 35, PW2. He is also independent witness. Police personnel called me to sign the seizure list. I have not read the content of the seizure list. I have not seen the powdery substance. I was informed by the police personnel that the powdery substance was brown in color, which they suspected to be heroin. I was not present when drugs was actually recovered from the vehicle. I had not gone near the XUV 500 vehicle when it was searched. I do not remember the date. I am not able to recognize the accused Akum Chang. So both the independent witness, they were not present. It is the clear evidence, my lord. This is not the paper. It is an evidence on record. And thus from their evidence, and your lordship, I have already pointed out that apart from this PW 1 and 2, there is no other independent witness in this case. All other 9 are official witness. So they have said the discovery was not in their front. So that is an admitted fact that section 52, my lord, violated. Therefore, my lord, my another argument, my lord, your lordship kindly for a moment peruse the FSL report. My lord, have it. I have not annexed it, but it is there in the.
Is there, it is there.
Yes. FSL report, your lordship will find one seal envelope having facsimile of seal such and such, along with seal impression such and such, marked as lot 1. My lord, kindly note it, my lord. Sample A, having a closed polythene packet containing such and such gray color powder substance, marked here as such and such positive test for thebine. Your lordship, then my lord, kindly my lord turn back to page 14 of my petition. Page 14.
Yes.
Here, my lord, this is FIR. One plastic packet suspected morphine containing 836 gram marked as P1. My lord, got it, my lord. One plastic packet suspected morphine containing 1014 gram marked as P2. This PW3 in his examination chief, same description has been given. Same description in the definition of PW3 or lordship will find. So apparently 2 samples were taken. This is this is apparent from these 2 records that 2 samples from 2 polythene packets were taken. In one, it was weighing 836 gram and the another 1014 gram, totaling 1.80 something, my lord, 1.800 something grams. But samples sent to the FSL only 1 packet. There is also a clear violation of the statutory mandate. FSL says one packet, CGR memo, evidence shows 2 packet. So sample ought to have been sent to the FSL from both the packets. That cannot mix up together. This is not permissible under law. Either the IO has mixed up the sample or he has sent only one. His cross-examination is still deserved. I would, my lord, cross him on that point. So these are my humble submission before your lordship, my lord. And my last but not my lord point is that, my lord, I am a local resident, my lord. I am not an outsider. And 60 years of age, my lord. And considering the age, my lord, 61 years age and length of detention, my lord. Any terms and conditions, my lord, may provide. That's my argument.
Okay. Yes, Mr. Sharma.
Yes, Lordship. Yeah, Lordship, as has already been pointed out, Lordship, charges were framed on 18/4/24, Lordship. Thereafter, Lordship, the three PWs has already been examined, Lordship. And Lordship, as has been indicated, Lordship, one of the clause has been reserved, Lordship. So, Lordship, regarding delay, Lordship, I find there is no delay, Lordship. Absolutely no delay, Lordship. Trial is progressing at a fair pace. Now, regarding, Lordship, the Thebine, Lordship, this is a frivolous ground, Lordship. Thebine and morphine, Lordship, they are chemically similar, Lordship. They have same chemical formula, Lordship. So, আপুনি কৈছে নহয় কিবা কথা না মই এইটো কোৱাত কিবা আপত্তি আছে আপোনাৰ ইণ্টাৰাপ্ট নকৰিব Lordship, thebine and morphine, Lordship, both are having same chemically similar, Lordship. So that is a very frivolous point, Lordship. Now, Lordship, regarding the delay, Lordship, it's already seen there is no delay. 3 PWs has already been examined out of 11. And Lordship, regarding section 37, no submission has been made. That is a paramount important. Let him satisfy, Lordship, regarding section 37 to your Lordship. If Lordship, this is held to be delay, then Lordship, I have nothing else to say, Lordship. And Lordship, regarding the independent witness also, Lordship, if kindly goes to the particulars of prosecution witness, Lordship, PW2, he is a business, Lordship. He is into business, so I guess he is also an independent witness, Lordship. Bijon Paul, he is yet to be examined. And Lordship, even if I'm not admitting, Lordship, even if the independent witnesses do not support, Lordship, conviction can be based on the official witness also, Lordship. It is not necessary that one of the independent witnesses have to implicate the present petitioner, Lordship. And also another point was raised, Lordship, that he was a passenger in the vehicle, Lordship. There were only 2 persons in the vehicle. Both have been arrested, Lordship. That is my humble submission, Lordship. Regarding section 37, Lordship, there are number of cases I need not point it out to you, Lordship.
What about drawing of samples and what about it?
Lordship, all these points have not been raised before. And if Lordship needs further discussion, Lordship, regarding that, I will have to go to the records, Lordship. Otherwise, delay part, Lordship, there is nothing.
You go to the record.
Lordship. Only on the point of 52A, Lordship. Otherwise, there is no ground.
Go to the record.
Lordship.
And also go to the fire.
Lordship.
And the inventory.
Lordship.
When?
Lordship, let it be on, if possible, Lordship, next week, 13, Lordship.
Okay. Record. So we'll leave it on 13.
Just one,
List on 13.
so the updated records may be called for also because the last date was 25/11.
As it is.
As it is.
We'll look into it.
Look, today was fixed. I'm obliged.
The next case, who is there?
Lordship, 483 application, FIR is at page 12, your Lordship. Allegation under section
Yes,
21B.
report.
Already 62 days, your Lordship, as on today.
Lordship, FSL has not been received, Lordship.
Was arrested on 5/10, your Lordship.
Just. You have the case diary? Yes. Kindly put it. You are Mr.
SL, your Lordship.
Counsel appearing for the Mr. P. Sharma. Petitioner name. Was arrested. Actually, 1510-2024. And the chapter corresponding to DL number 5890/20. From his position, 12.5 grams of suspected heroin was recovered in presence of independent. Considering his rank of detention in custody, 520. Petitioner name above filed his bail application on 4/11/20. On being inquired, Mr. Sharma and additional court prosecution that though investigation is complete, but due to non-availability of the FSL report, search sheet in the case could not. Considering the detention of the petitioner since 5/10 to this. Petitioner is in custody for more than 61 years to date, and thereby completed mandatory period of detention. Whereas the state/prosecution failed to submit the search sheet within the statutory time prescribed. And let's share this as per the act in force. Considering that the petitioner is entitled for revolving inside 50,000 to location condition of Friday. We have so satisfaction of special box, sorry, NDPS from session that Kamrup Metro Park. Shall appear as not leave. The conduct case.
The scanned copies of the case records were called for.
Lordship, regarding service of notice, Lordship, I will have to take instruction, Lordship.
That is complete, my lord. When was it taken?
Service?
This is not really. Earlier occasion also you have been given time.
We have
You
communicated.
received on 14/11.
Yes, Lordship.
My lord is also doing.
No, I understand. We have to take instruction.
Okay.
Next week, Lordship, we'll take instruction, Lordship.
Give us a date. Monday?
Monday, Lordship.
Okay, on 9th?
Monday.
Wait on that.
Coming Monday, huh?
We'll have it on 9th.
My lord.
Lordship.
Enabling Mr. B. Sharma to apply the court authority
Thank you.
status of service of notice of respondent. Informant respondent number 2.
36 को मुड़े
ठीक
nine.
Lordship, may I plead? I am praying for regular bail under section 483 of the BNS. Lordship, the gist of the affair is that manholes from Sunmari area was stolen. So the police apprehended 6%. And on their confessions, they apprehended some 6 individuals from Romania also. I am the one Jaherul, I am praying for, bail for Jaherul Ali. Now, in my petitions, I would like to read out para number 4. The accused petitioner was the employee of the company where the Anil Goenka is the manager and Amrit Kumar Sindhi is the CMD of the company. The accused Jaherul Ali left the company job and he went to his friend Azad Ali to collect his last month's salary. At that time, the Sanmari police apprehended Azad Ali and they also apprehended Jaherul Ali. So I have nothing to do. I was an employee of the company. I went to my friend Azad Ali for collection of my last month's salary. And in that, Azad Ali was also apprehended. So the police also apprehended me. And
Yes,
my length
Mr.
of
Sharma.
detention is 15 days.
Lordship, if I may just point out, Lordship, one thing before Lordship.
Just a minute, please take your seats. We'll be signing a particular.
Lordship.
Babulo. To promote the immediately approved. Difficulties were good. Yes, case diary.
Yeah. If I may just point out one thing, Lordship. Lordship, regarding the BA application item number 7 and 36, Lordship. These are on a different footing and the AB is in a different footing. So if Lordship permits me, I will first submit on the bail application, Lordship.
We'll go through it.
Yes, Lordship. May I just point out one thing, Lordship? Lordship, these 6 persons were arrested from Kanmai, Lordship. They were working in the guise of GMC workers. They were arrested, Lordship. They are not before your Lordship. They were contacted by Lordship, the petitioner number in item number 7 and 36, Lordship. These 3 persons, Lordship, I have flag marked the statement as well as the statement of the workers who were arrested. The workers were paid 1,000 rupees and 500 rupees daily for collection of the manhole covers, Lordship, by these 3 persons. Then these were transported to Lordship in Rania, in a scrap dealer, Lordship, it was transported. There, Lordship, it is called, Lordship, KD Iron and Steel Private Limited. In their, Lordship, the vehicle in which it was transported, he has also been arrested. His statement is also on record. Now, Lordship, what has happened, Lordship? In KD Iron and Steel Company, Lordship, there one person by the name of Amrit Kumar Siddha, who happens to be the manager of the AB Metal, Lordship, the present person, Lordship. This manager, Lordship, Amit Kumar Siddha, he is already arrested. He has been, he bought these items, Lordship, for some amount that has been mentioned in the case diary, Lordship. That is the whole case, Lordship.
Do you have cast iron manholes in the footpaths or other places? Have you noticed?
Lordship.
Where it is available? These are all
Especially in
cemented.
the drains and
Mostly cemented and slabs.
yes.
Where you have noticed?
Mostly in drains, Lordship, covering porthole. Manholes in the bylanes, Lordship, in the
Violence.
bylanes. Lordship, here the allegation is twofold, Lordship, including taking out the manholes as well as taking those manholes in the guise of GMC workers, Lordship. There are 2 parts of allegation.
Session for pending, please take 15 days.
Those ideas.
Please take 15.
Wait, yes. Editor.
March 50, only going.
Oh,
Please take
okay.
it.
Manager. Manager.
It's all right. It's good.
Let them aside. Let them aside.
Okay, we'll come back at this. For the order.
Lordship, prior to that, my lord, I just want to, but out of that, my lord, 2 accused has already been granted bail by the additional session judge. In the meantime, on last 1 or 2, and the my lord in item 7, petitioner number 1 and 2, they are no way connected. Nothing has been recovered from them, my lord. Out of suspect, the main accused in the FIR, they are not the named accused.
You are appearing in item number 7.
7, man.
Also appearing in,
Not my lord, my lord.
you are appearing in 7, right?
Yes.
You are having 2 accused.
Oh, 2
persons.
persons.
You are appearing in item number
36.
36. Who is appearing in the other item?
48.
Oh.
Lordship, just 1 minute. The 2 owner, that is that Amrit Kumar and Amrit Kumar Siddhi and Anil Goenke has been given bail by our district and session judge. And the point has been noted that section 30, all these offences are below 7 years. So the means 30, under section 35 clause 3 of the BNS, the notice period has not been complied as per our judgment of Satyendra Kumar Antil versus Central Bureau of Investigation. So Lordship, this point has to be taken into consideration.
From the record, we'll see if anything has been served or not. Okay.
My name is not in the FIR, and there is only on the notice I have appeared, and I am ready to appear and cooperate with the Thana concerned. There is nothing, and there is nothing on my part to play before the thefting gang. That is, they have done at their own end, and the materials was recovered from there. Nothing has been recovered from my custody, Your Lordship. I have no business with that. And Your Lordship, that is the page number 23, Your Lordship. I was out of station from 7th of November till 19th of November. So to whom they have contacted and how I play a role in this episode, I do not know. So somebody has recited my name, so that does not mean that I have involved in the issues.
Sure. We'll look into it. Yes, you want to say something?
Item 7, my lord. So, my lord, here in this case also, my lord, petitioner is nowhere involved. Nothing has been required from his custody, my lord. Only out of suspect and information that he used to purchase the stolen materials, my lord. But from his shop, nothing has been recovered. Item number 7. And also, my lord, for that 35(3) has to be complied. That is the judgment for High Court of September. That I heard. And also, out of 4, 2 has been granted bail by the trial court also. That may be considered into consideration.
Definitely. Is this the order? Okay. Which order you would like to give in your case? That order passed by limitation?
Yes, it is there.
Okay, we'll look into it. We'll pass the order tomorrow.
Obliged, Lordship.
Yes, Mr. Halloy.
Yes.
Item number 12.
That
instruction was sought for. Mr. Parasar, you are there in the item number 12. That Dhuri matter.
Actually, I have been informed from the office that CD has been received. So if Lordship fixes a date, we can.
CD has been received?
Yes, Lordship.
Tell us when, Monday? Monday.
Deeply.
66. Yes, Mr. Holloway.
Lordship. On the last occasion, I was asked whether any new materials, Lordship. During that period, Lordship, we have recovered one diary, Lordship, where from Lordship it reveals that he has received some another payment from DB stocks, Lordship. So with that regard, Lordship, only statement of witness has been recorded. The Lordship will find, Lordship, apart from the admitted amount in your petition.
Admitted amount?
You have written your petition, what are the amount you have received from DB stock. Apart from those amount, another 14 lakhs rupees has been received by this accused person, Lordship. That CD will reveal, Lordship.
Give it to us.
Lord. Diary dikhai or and the statement of witnesses, Lordship. He is the internal auditor. Basically, he is the internal auditor, and he used to manage all the monies of DB stock, Lordship, by preparing certain false document, Lordship. And on the basis of those document, Lordship, the external auditor, Lordship, only passes the pay and paid the GST, Lordship. So the external auditor has given their statement, Lordship. Those statement will reveal the fact that it is this accused person who is manipulating the affairs of the company, Lordship. Farm, DB stock, Lordship.
No, you do not want to see the diary, you want to see your case diary.
Case diary. No, that is the diary which has been recovered. Lordship. And on the basis of that case diary, Lordship, I mean to say diary, statement of witnesses were recorded. The statement of these are done.
That is a part of evidence we do not want to.
Correct, Lordship. Diary to nalage din. The money which has been deposited in the account of DB stock, Lordship, this accused person used to convert those money in the form of loan and Lordship consultancy service, consultancy amount, Lordship, services. Fees for the consultancy, which are not, Lordship, they are not entitled to do that as per unregulated deposit scheme, Lordship. Balance in the balance. This one is important. आम का ऊपर में क्यों मार देता है? आम का ऊपर
Anything else to submit, Mr. Haloi?
Lordship, this is one more diary, Lordship, case diary, with the statement of some other witnesses also recorded, which has established the fact, Lordship, that this accused person, Lordship, he used to maintain the accounts, Lordship, all the accounts of DB stock, and he used to, Lordship, write about the loan and, Lordship, consultancy service, Lordship.
No, that
The
is
amount-
already you have stated.
Yes.
That he being the chartered accountant was also a material for purpose of managing the accounts,
Lordship.
flow, everything. What else that we have considered in earlier bill, right?
Those things has been considered, but there are recent, Lordship, statement of witnesses, which has been recorded, Lordship, on the, which would prove the fact with regard to the diary, which has been recovered recently, Lordship, 14 lakhs rupees, Lordship. They have not stated about the amount that has been received by them to the and Lordship, with regard to the external auditor, the statement was recently recorded, Lordship. He has also stated that it is this accused person, Mukesh Agarwala, who used to do the internal audit and produce all the documents of the firm to him, and he simply signed the papers. So those things are not prior to rejecting the bill. Those things are not in the case diary, Lordship. These are the new facts. On the last occasion, Lordship, before the bill was rejected, their submission was that they used to do only the audit, no documents, no book of accounts they prepared. So those things are not there, Lordship. Now these witnesses have stated and proved the fact that it is he who prepared the document, Lordship, of DP stock, Lordship, and against that he used to receive the money. And on the last occasion, Lordship, Dipankar Burman has also stated, Lordship, that fact has been considered.
That we had considered in the
Yes,
earlier
32
case,
lakh, yes,
right?
32 lakhs, with regard to that 32 lakhs, Lordship, already considered. Now this 12 lakhs, Lordship. 14 lakhs, sorry, Lordship, 14 lakhs. New facts, Lordship. During this limited period, Lordship, we come across. Nowhere they have stated that this 14 lakh rupees has been received by this accused person in their petition, Lordship. And the signature appearing in the diary has also been identified by the witnesses. In the first petition, Lordship, they only admitted about the fact that they received 27,000 as their consultation fees. Subsequently, when we filed our objection and where we have written about the other amount that has been received by this accused person, now in their new petition, Lordship, they have mentioned those amount also. And now this 14 lakhs rupees has not been mentioned, Lordship. Nowhere your Lordship will find in their petition. Every day, Lordship, they are taking new stand. Initially 27,000, now this three amount they have admitted in their petition.
Mr. Halloy,
Lordship,
give a short note by tomorrow. We'll pass the order on 9.
Lordship, highly valued.
May I argue, my lord, my part, my lord, he will give a note, my lord, no issues. My lord will kindly come to my bail applications, my lord, paragraph 19. The new grounds on which I am moving this petition, my lord. My lord rightly pointed out at the inception itself that at that stage it was rejected, my lord, considering the stage of that it was a initial stage, nascent stage. Paragraph 19 of my petition, my lord, what development has taken place in between? In paragraph 9.1, my lord, that the CBI has taken custody of the petitioner from 8/11 to 14/11, page 11 of my petition.
Right.
And thereafter, he was sent to judicial custody. Be stated that the Honorable Court allowed 8 days police custody and he was sent to judicial custody. Now, so far with regard to custody period, so far detention is 90 days is concerned. First 60 days, that is already over. They cannot take me into custody, my lord. So keeping me behind a bar for any other reasons, my lord, I don't see. During police custody, Dipankar Burman was brought for interrogation with the petitioner, where he admitted that he used to take loan from various people by entering into agreement in his device, and the petitioner has no role in it. Am I clear, my lord? When being confronted in joint interrogation, he has stated that. And my lord will kindly see, Dipankar Burman has been running that particular scheme from 2018, and by way of an agreement, entering into agreement. And I know Dipankar Burman, as for their objections, I will come to their objection with regard to this. About the WhatsApp message, my lord, on the last occasion, some kind of messages were sent. Yes, there is a message in my mobile, which I admit, that Dipankar Burman wanted 2,000 note this 2,000 notes rupees, my lord. And I was contacted. I said, like, whoever furnished it will take a percentage of charging 2.30%. But this money was never been, my lord, this with regard to exchange of 2,000 note never took place, my lord. Next, my lord, the petitioner was taken his professional fees I have mentioned about, further GST 20,000, 30,000 paid. Now, these are taken by way of bank transfer, my lord. Whatever reasons, my lord, GST, my service tax, whatever. The CBI is pressurizing the petition to admit receiving an amount. So they are saying they will make me an approver if I accept 32 lakhs. My lord, one hand they say that whatever money has been paid to me is been reflected in the diary they are producing it before this honorable court. And on the last occasion when the objection was made, the 32 lakhs, my lord, it was pointed out to this honorable court. Now the 32 lakhs whether entry is there in the diary, my lord, first of all, my lord, it is not there.
That is a part of the evidence. We are
Absolutely. My lord, that's not been there. They have brought on record by way of a, my lord, affidavit. So that entry of 32 lakhs is not in the diary, my lord. Their case, my lord, the objection filed on the last occasion is this, that Dipankar employee came in, my lord, and handed over 32 lakhs to me. That was his case. And now, while during, my lord, this joint interrogation, he said he came and gave 32 lakhs. And these are the statement of an accused person who had defrauded people at large, my lord. And by way of an entering into an agreement. Two different versions, my lord. As for their first affidavit, my lord, while bail was rejected, it is his employee came in and given me 32 lakhs. If anyone is fool, my lord, that any amount of money has been given, 14 lakhs, 20 lakhs, 22 lakhs, no acknowledgement will be kept. That too by a person like Dipankar Burman, my lord, for which he enters into agreement with certain persons, my lord. Absolutely nothing, my lord. Next ground, my lord, will come to. Dipankar Burman admitted before the petition that the petitioner never solicited any client or promoted his business. The petitioner is not managing the bank of Dipankar stock consultancy, but only dealing with preparation stock, maintaining balance sheet on the basis of statement of account provided by Dipankar Burman. Amount received in the bank of the petitioner partnership firm is for GST, TDS as well as service tax. And that's been paid to the department. It shows. Amount received from Dipankar Burman for his service provided to him. When received in cash, invoices are received and on the basis of which he received the payments. Whether there is an invoice of 14 lakhs, my lord. A person, I am giving someone a 14 lakhs, there will have to be an invoice. Where is the invoice? So stating all such facts will not do, my lord. All bank statements, other documents were sent to the petitioner and the email speaks in volume. They are not producing the emails. Why? Because of the fact that email as per instruction is been produced, the balance sheet from where this money has come. So entry has to be made in the statement of accounts. The CBI submitted before Honorable Court, the CBI could not collect list of transactions made in favor of Dipankar Burman Consultancy for which they opposed the bail application cannot be a ground for languishing in jail. Last time it was, my lord, that was the ground. In paragraph 16 of the order dated 13/11/2000, it is reflected that the petitioner acting as a financial advisor to Dipankar Burman and advised him assessing the deposit amount by making false consultation invoices showing the deposit investment as lows in the bank account is a statement made by accused which is inconsistent with the record. In view of the statement made in the affair that Dipankar Burman by making an agreement promising high returns. There are agreements with each and every individuals. And Dipankar Burman girlfriend has been charge-sheeted. And in the charge sheet, I'll come to that. They are not putting it before the honorable court. The whole affair is said that agreement on the basis of Dipankar Burman has taken a loan. So where is the question of soliciting or giving him advice? High return. Further, the fact if the petitioner, financial advisor, he ought to have received money every month as salary. Where is it? And sir, a term has been used by learned PP today that internal auditor. Sir, this is a legal term that is been provided under the Indian Companies Act. This is not even a company, my lord. For internal audit, my lord, it's being a statutory authority. I cannot do internal audit as per the company's law. Next ground, my lord, will kindly see. The allegation of taking huge money of the petitioner from Dipankar in cash is a false statement. And when confronted in front of the petitioner while severe custody, he stated that he paid the aforesaid amount directly to me in my office, which contradicts his previous statement of Dipankar. Because their previous, my lord, affidavit in objection, my lord, stated that a person came in, employee came in and gave it to me. Now Dipankar said he directly gave it to me. Earlier he stated he sent through his employee in view of the fact that no person sent money without an acknowledgement which is reflected in the rejection order. In paragraph 17 of the order dated so and so, it is submitted by the learned PP that through his financial knowledge helped the prime accused Dipankar is false in view of the fact that he provided service to Dipankar Verma as per his instructions. In paragraph 19 of the order dated CBI relied on a judgment reported in 2013 7 SCC. FOC is not applicable against the present petitioner, Jagan Mohan Reddy, my lord. 7 CBI cases were pending and thereafter all released on bail. He became the CM of Telangana, my lord. And thereafter, my lord, he lost the last election. Rampant corruption by a politician, I have stated in this whole paragraph, my lord, with regard to the facts of the case. Immovable property, my lord, in crores and crores. In the aforesaid German case relied on the PP, there are 7 more cases against the same accused. The aforesaid person was subsequently not only released on bail, but also contested the election, becomes Chief Minister of Telangana. That the mandate of law under section 41A, now under 35(3) is not being complied with in this case, and as such the initial itself, it's bad in law. Because my lord will kindly see, by adding sections of law, the court has to appreciate it, that a case is made out or not against that. Whether it is a single person, witnesses, who stated that they entrusted money to me, which I have misappropriated, which is the 2 limb of 409 and 2 limbs of 316. Entrustment and misappropriation. No allegation with regard to entrustment by any person concerned, and I have misappropriated. Who is the question of 420 and my lord, this 405 ingredients and 316 ingredients? Absolutely nothing. 316 is not applicable against him as he is a service provider as per the CA Act. The law laid down by the Supreme Court made it clear that when a special law, it has been applicable on the facts of a case, adding sanction of IPC will not be applicable. I'll show that particular law.
Mr. Bhuya, all those things on earlier occasions.
Yes, my lord, but that was not met with, my lord, in the judgment, my lord.
That's
1311.
You have considered the judgment.
Yes.
Is there.
That the petitioner backs in judicial custody for more than now 70, nearly 75 days, my lord. And considering the length of the, your lordship will be pleased to release the petitioner on bail. Next, petitioner backs there is no likelihood of absconding or fleeing from justice. Further, the petitioner respectfully submits that he will appear before the court, honorable court, as and when directed, will certainly not hamper the investigation with evidence. And these are the mobile numbers. Nothing has been found and been placed before this honorable court. My lord, these are sum and substance, my lord. And apart from that, I want to place the, my lord, the report. Because one has been charge-sheeted in this case. And the charge sheet is dated 18/11, my lord, 2024. My lord will kindly come. This is against one lady, my lord, Mona Lisa Das, the manager of DB Consultancy. My lord will not find brief of the case. Paragraph, I take your lordship directly wherever, my lord, my name has been mentioned, my lord. At page 8, my lord will kindly come.
You just give us the concerned page number.
Yes. 16.14, my lord.
Page number 8.
Page number 8, my lord. And I, my lord, may underline it, my lord. There, Dipankar came in contact with Mukesh Agarwal, chartered accountant who had his office in vicinity of Dipankar's office. Mukesh Agarwal advised him to open current accounts and to file GST returns. Yes, I have advised. Because he cannot do business in a saving bank account. And if he's been providing, he's been taking money on loan and, my lord, promising high returns, he has to pay GST. What's wrong in that? On the advice of Mukesh, Dipankar opens various saving and current accounts in the personal and proprietorship in various banks that I don't have to do anything with regard to it. Next page, my lord, nothing has been there. Next page, my lord, will kindly come to page 13. Same ground that was taken on the last occasion. Page 13, my lord, paragraph 16.22, my lord, 1, 2, 3, 4, 5, 6 lines from last second paragraph, my lord. It's been stated out here, my lord. It is further stated, revealed that fake invoices were prepared by DB Consultancy in conspiracy with Mukesh Agarwal. That's all. Now, whose invoices are there? Who have promised to give high return? Who have issued money receipt to the particular persons? By bringing my name will not help. And this is the accused person's statement. And during police custody is not at all admissible evidence, my lord. Next, my lord, will kindly come to. Nothing is there against me, my lord. At page 21. Now, who has prepared this, my lord, fake consultancy bill? According to the search sheet, my lord, will kindly come to, my lord, page 21. First, second, third, fourth, fifth, my lord. Pointed out, my lord. Fake consultancy bills invoices were prepared at Ulubari, and she was overall in charge of all affairs of the proprietorship, being assistant manager and close associate of Dipankar Burman. Now the prosecution has a different story, that she even forced the signature of Dipankar Chaudhary with regard to consultancy. What is their case? My lord will kindly come to now next page at page 22. 16.39. Further investigations continued one so and so, so and so, so and so. Dipankar Burman, Pooja Patel, Ranjan, so and so, Rakesh, so and so, Gaurav, so and so, Jyoti, so and so, so and so, and Mukesh Agarwal. Page 20, my lord, 2. Paragraph 16.39. My name has been introduced. Now, my lord will kindly see it's very important that the list of witnesses and, my lord, the document they are relying on, my lord, after filing charge sheet. My lord will kindly see the first annexure A. Mahesh Razak, employee of so and so, so and so, so and so, so and so, will prove association of Angel. My lord will not find anything against me. What they will prove, my lord, is there. The manager doesn't speak or make a whisper against me. Dipankar Burman, who is an accused, standing in the character of an accused, as per Maninder Singh's case, my lord, anything said or done by an accused while in police custody is not admissible, my lord. He can say so, my lord, to escape the truth. These document, my lord, nothing, letter dated so and so, so and so. These are the letter dated, my lord, so and so, so and so. Nothing is there against me, my lord. Nothing, my lord. Absolutely nothing, my lord, to point out to this honorable court. Now, my lord will kindly come to annexure B at page 41. File number 5. That is against me, my lord. File number 5 at page, my lord, 41, list of documents containing audit report of the year 2022 of DB Stock Consultancy Auditor. Who was the auditor, my lord? Rajesh Kagiwal, chartered accountant. Each of these files is bearing signature initial Vishal Das, Sub-Inspector of Police, so and so, so and so. Now, file number 6, my lord, containing income tax return of assessment, so and so, in respect of department and copies of statement of accounts. My lord, is being filed, so and so, so and so. And these are the statements I have provided before my arrest. Before my arrest, my lord. And nothing else, my lord, with regard to anything being recovered from my house has been charged, my office has been charged, and whole of the laptop they have taken in, the not the computer system, the hard drive. And anything, nothing is else against me except at page 61, my lord, will kindly come. Page 61, item number 39, my lord, with regard to the search list dated 26/10/2024, Kunal Lalora White, which 2 documentaries, so and so, which has been recovered and seized from the resident office. This is office, my lord, premises of Mukesh Agarwal. My house was some 1 lakh or 2 lakh rupees was found. They have not seized it, my lord, they have returned it to us. And that's where, my lord, factual metrics of this case. And my lord, I rely on certain judgments, my lord, that what is the purpose of, and these are all CBI cases, my lord. Sukram's case, my lord.
Okay.
That is 96, my lord, Delhi High Court judgment, my lord. Here, my lord, cash amount of Indian currency of 3 crore 61 lakhs 80,000 so and so is found. 10 lakhs 30,000 found, my lord. The operative portion is paragraph 8, my lord. I'm reading it, my lord. At the stage of considering the application of the petitioner for the grant of bail, the court is not required to go into detailed examination of the evidence and prejudge the case. And for that exhaustive exploitation of the merit of the case are not required in the order. The court, before granting bail in cases involving non-bailable offence, is to take consideration matters such as nature and seriousness of the offence, the character of evidence, circumstances which are peculiar to the accused, a reasonable possibility of the presence of the accused not being secured at the trial, reasonable apprehension of witness being tampered with the larger interest of public or state, and similar other consideration. Bail should normally not be withheld as a punishment if, after taking into consideration those factors, the accused is analyzed to go on bail, my lord. The next paragraph, my lord, the contention that has been raised, my lord, I am not reading it, paragraph 9. In between, I am reading. The question is whether bail can be refused to a person merely on the ground that some of the pages of the diaries have yet to be decoded, and how much time it will take to decode the diaries is not known. Even to the investigating agency, can bail be refused on the ground? There is still an uncertainty about the person who may be involved along with the petitioner on account of diaries having not been decoded, my lord. Ultimately, my lord, he has been granted bail, my lord, paragraph 11, my lord. And with conditions, my lord. I am ready to go by the condition. Next judgment, my lord, will kindly come to, my lord. This is, my lord, again, Delhi High Court, my lord.
You have already given the judgment.
Yes, no, this judgment I have not put it before the court, my lord. Paragraph 7 and 8, my lord.
Paragraph 7, 8.
Yeah, I am reading paragraph 8, my lord. The petitioner is a senior government officer of the government of India. She has roots in her family residing in Delhi. I therefore do not see any reason why she should flee from justice. On the basis of affair and materials on record, I feel the entire case is based upon the documents. Premises of the petitioner has already been charged. I do not feel any further recovery is to be affected. She has already been interrogated during the time she was in custody. I do not feel any further investigation to be carried out. In any case, if any further investigation is to be carried out, the petitioner enlarged on bail will always be available for investigation. During the course of argument, it was informed that Mr. Lal that another case of possession of assets of disposal to her known source of income has been registered against the petitioner. However, I am presently not dealing with the case, so and so, he has been granted bail, my lord. Now, next case with regard to Punjab and Haryana, my lord, KK Jairat case. That, my lord, 72.82 lakhs case, 2 affairs were there. Ultimately, the Honorable High Court granted bail, my lord. And the observation is very important, my lord. The apprehension of the prosecution regarding the likelihood of the 8 witnesses being won over may be real, but the prosecution should have confidence not only in its own witnesses, but also in itself in the capacity to safeguard the interests of the state and to ensure the witness deposed at the trial without fear. So and so. His bank account has been seized, and in the case of properties have been seized, at least there is prohibition on their allegiance. So bail was granted. Now, my lord, another judgment, my lord, Lalu Prasad Yadav, my lord. He was also granted bail, my lord. That's Chara Ghotala. It's a big one, my lord. And another judgment, my lord, I rely on, my lord. Yes, Sanjay Chanda, paragraph 39 to 43, my lord. This is the principle of law, and as on today, it's a good law, my lord. Coming back, paragraph 39, my lord, coming back to the facts of the present case, both the courts have refused to refuse the request for grant of bail on 2 grounds. Primary ground is that the offense alleged against the accused is serious, involving deep-root planning in which huge financial loss is caused to the state exchequer. The secondary ground is that the possibility of accused tampering with the witnesses. In the present case, the charge is that cheating and dishonesty induced in delivery of and forging for purpose of cheating using a genuine forged document. The punishment so and so. Paragraph 40. The grant or refusal to grant bail is within the discretion of the court. The grant or refusal is regulated to a large extent by the fact that the circumstances of each particular case. But at the same time, right to bail is not to be denied merely because of the sentiments of the community against the accused. The primary purpose of bail in a criminal case are to relieve the accused of imprisonment, to relieve the state of the burden of keeping me pending the trial, and at the same time to keep the accused constructively in the custody of the court, whether before or after conviction or so and so. This court in Gurbaz Singh case might observe that two paramount considerations while considering a petition for bail in a non-bailable offense. Apart from seriousness of the offense, are the likelihood of the accused fleeing from justice and his tampering with the prosecution witnesses. Both of them so and so, so and so. From when the under trial prisoner are detained in jail custody to an indefinite period, Article 21 of the is violated. Every person detained or arrested is entitled to so and so, so and so. Here, my lord, 17 accused persons were there, my lord, and they were granted bail. Paragraph 46 is very important, my lord. We are conscious of the fact that the accused are charged with economic offenses of huge magnitude. We are also conscious of the fact that the offense, if proved, may jeopardize the economy of the country. At the same time, we cannot lose sight of the fact that the investigator has already completed investigation and charge sheet is already filed before the special judge CBI, New Delhi. Therefore, their presence in the custody may not be necessary for further investigation. We are often so and so, so he was granted bail with conditions, my lord. Next judgment, my lord, at page, my lord, is of P. Chidambaram, my lord. Now, here was the person was behind the bar for 2 months, my lord. And the amount that has been involved is 305 crores. And what the Supreme Court stated, my lord, that he will be, he may flee, my lord, and all such things. 305 crores, my lord, involved in this. And what the Supreme Court has stated is very important, my lord. In paragraph 33, my lord. This appellant is not a flight risk, and in view of the condition imposed, there is no possibility of abscondence from the trial. Statement of prosecution that appellant has influenced the witness and there is likelihood of his further influencing the witness cannot be a ground to deny bail. And as such, he was granted bail, my lord. And Dataram Singh's case, my lord, 2018, 3 SSC, page 22, my lord. Paragraph 3, 4, and 5, my lord. Here, my lord, even arrest is not necessary, my lord, in certain cases, wherein my client has produced all the statements of account, whatever it is in his custody to the CBI. And as such, he has been granted bail, my lord. In this case, my lord, another judgment is to be a 30409 case make out Hussein and Aisa. The main crux of this case is that he has crossed the mandatory period, whatever it is, my lord. 409 is not made out. Neither is a public servant, not is an employee or otherwise. And otherwise, my lord, 405 have two limbs. One is entrustment of money to me, and I have misappropriated. And who is saying that? An accused person. Case is not that. Case is that public money has been taken by Dipankar Verman by way of an agreement, which is illegal, previously under the Chit Fund Act, now under Bugs Act. That is the prosecution case. And 3165 is nothing but word to word, same as 405, my lord. So I have crossed the, my lord, the mandatory period. 405, these are not attracted, my lord. And that is Arnab Goswami's case. Section of law has been put so that detention period could be 90 days. That cannot be a ground, my lord. A duty has been cast on this Constitution Court to look into it, my lord. What the learned PP is saying, that previously 32 lakhs in their objection, my lord, they have stated. Now, whether the diary contains 32 lakhs, absolutely no. Previously, they have stated on affidavit that an employee has come and given it to me 32 lakhs without any acknowledgement. These 32 lakhs, there is no entry in the diary. So that falls flat. Now they comes in, there is an entry in the diary, 14 lakhs. These are subject matter of trial, my lord, not at this stage, my lord. Why my custody is necessary? after 75 days in custody, my lord. I have my children, my lord. I'm the proud father of a recently, my lord, born child. My wife is there, my mother are there, my lord. If at all charge sheeted, I will face the trial, my lord. And even I suggested to them, my lord, I can be an approver, provided that they don't force me. 32 lakhs you have taken. Why I'll take, my lord? Nobody will give part with 35 lakhs without an acknowledgement, my lord. That's my respectful submission, my lord. No purpose would be served if my clients are behind the bar. And no criminal antecedent of this particular person, my lord. I have stated on categorically, my lord. Once upon a time, I give advice to some persons, my lord, I become an accused. And under the Chartered Accountancy Act, there are guidelines. You cannot arrest. You have to give a notice under 41A. And they are saying and they are agreeing to it. But there is no notice under 41A. Because they jumped the 41A by putting, my lord, 406. That is, my lord, very vicious, my lord. And that cannot be allowed in this case, my lord. That is my respectful submission with folded hands. Whatever conditions, my lord, put in, my lord. Lot of sufferings, whole family has suffered, my lord. And for that purpose with foldings, as I pray, my lord, he may be released on whatever conditions. If he have to daily go to the CBI court, he'll go. And he will participate in this investigation. On the last occasion, learned PP said, he is cooperating in this. That was a statement made in this bar, my lord. Why my custody is necessary, my lord? I take your leave, lordship.
Lordship, in reply, Lordship, now they are taking the stand that there is no mention about this 32 lakhs. Initially, in their petition, they admitted only 27,000 as a professional fee. When we stated those things that these are the amount, apart from this 27 lakh, 27,000, these are the amount he has received. Second petition, they have moved after rejection that these, yes, these are the amount. Now, let me, please. Lordship, investigation was going on that time. We cannot ascertain what was the amount he has revealed altogether. Initially, when we investigate, we found these are the amount. Subsequently, this diary has been recovered. Out of this 32 lakhs, 14 lakhs rupees, there's an acknowledgement. And witnesses stated about the receipt of the money, Lordship. How can they deny those things? They are saying that there is no mention about 32 lakhs. But when your Lordship sees the diary, your Lordship will see the entry with his signature.
Which signature?
Let me. Yes.
Which signature? My signature?
Yes.
Hey.
You are not acquainted. Lordship, those things will come to know at the time.
Trial, you prove it.
Yes, definitely.
These are documentary evidence, you prove it.
Investigation is going on now. He cannot say that he can say, but as because investigation is going on, we'll try to find out about this 32 lakhs. Now we have received this 14 lakhs. Let us investigate. Let us find out whether the remaining amount out of this 32 lakhs is there or not, Lordship. Therefore, at this stage, I'm praying before this honorable not to allow him to go on bail, Lordship. That is my respectful. And regard to that, all the judgment regarding P. Chidambaram and all, Lordship. In P. Chidambaram, Lordship, it was a disproportionate asset, Lordship, if I'm not wrong.
This also
offense is with regard to disproportionate asset. So this is not the disproportionate asset, Lordship. The offense is under BATSEC, and subsequently, when materials has come on record, we have added 409. That order is still in force. They have not challenged. That order is still in force, Lordship. They cannot deny the fact that 409 is not applicable. And investigation is going on, Lordship, with regard to the involvement of this accused. Lordship has gone through the case there, and today I have, Lordship, placed before this honorable court with regard to the statement of witnesses, who regard the fact that this accused person not only give any consultation, but also, Lordship, is prepared the document before putting to the external auditor, Lordship. And the external auditor's statement may also be looked into, which he is also referring, Lordship. External auditor's reports Lordship may kindly have a look into the statement of the external auditor. He himself is stating the fact that it is he who prepared all the documents. And under his consultation, his advice, Dipankar Burman is taking the money as loan and so and so. So therefore, Lordship, let us investigate and complete the investigation, Lordship. They are saying that they are under the BATSEC, 409 is not able. Yes, now at this stage they can say, but let us investigate. If no offense under 409, will not charge him under 409. Conspiracy is there. If your Lordship sees the statement, conspiracy, Lordship. And the punishment with regard to conspiracy, punishment is same with 409, Lordship.
I am on one thing, my lord. What document is to be seized already been seized?
No.
Now, my lord, what my lord will consider,
from him,
my lord, what has to be considered is this, that bail a provision has been made, which has been tried to be made a redundant provision by interfering with the discretionary power of this court. What in Arnab Goswami's case has stated, my lord,
We'll take care of.
while dealing with a petition under 480 to quashing so and so or not considered whether the prima facie ingredients of offense is made out in the affair. If the High Court have to be carried out in the exercise, it would be held in its judgment apparent on the ingredients of the offense is not been prima facie established. So 405-3165 entrustment and misappropriation, and I have not entrusted with public money.
We'll look into it.
Yes, my lord. Deeply obliged for me.
And
And it will be a never-ending process, my lord.
Is not applicable. Why Jagan Mohan is heavily applicable in this case, lordship? Why is Jagan Mohan Reddy, lordship, though he is the chief minister, son of the chief minister, does that mean that all the accused person required to be chief minister, then only Jagan Mohan Reddy is applicable?
Mr.
I'm sorry, lordship.
Give a short reply or whatever you like more.
Well, I have
Ask the
concluded
order
my
on-
The
argument.
law laid down in Jagan Mohan Reddy, lordship, is applicable in this case, lordship. It is an economic offense, and therefore it is applicable, lordship. Highly obliged.
Whatever you want to give and give along with the whatever document you like to give tomorrow. But we're not
I'll
keeping
prepare a
it.
short note on this. Highly obliged.
Did you call it?
55.
Yes, Mr. Sharma, what is the status?
Lordship, probably LCR has not been received, Lordship, but service is complete, Lordship.
Service is complete.
Yes, there is an office note, Lordship.
Registry shall forthwith communicate. The office of the special justice of Bogandgaon pertaining to the records of special POXO case number 102 put in bracket Bogandgaon BZ and 2024 along with the copy of Bogandgaon PS case number 222 of 2024 list on 17.
May I please, lordship? Well, this is a trial case, lordship. I have lordship annexed two witness was examined. I have annexed this evidence, lordship, page 24 onwards, lordship. Victim and the informant. Page 24. I am behind the bar for lordship 145 days. 145 days. I am behind the bar. 56. 56. So this is 55. Hello. 56. I am for 55. 55.
That's in 17 period.
Service complete. Am I?
Capability. 17.
No representation.
56. Scan vacation is.
57.
Notice served.
Lordship, I will have to take instruction, Lordship.
LCR was called for lordship, and on that last day only we have taken the step upon the respondent number 2.
Huh? 1911.
1911.
Registry shall issue forfeit reminder. একে order করিব। Same date.
1911.
Special Judge POXO Kamrup Metro Guwahati. Potential number EPS case number 1855 of 202.
Dated at
My lord, in this case, my lord, petitioner, my lord, joined the my lord, 218 days, my lord. So, on the last occasion, my lord, on the.
Here also,
second time, my
Lordship,
lord,
we'll
we
have to
taken
take,
steps, my lord.
we'll have to take instruction, Lordship. Today morning also, Lordship, I have intimated. If Lordship kindly fixes a date, we'll take the instruction, Lordship.
Get the information by 9th. Thereafter, we'll fix it accordingly.
Lordship.
Obliged, my lord.
May I please your lordship? X-ray was called for lordship. Have taken
Please
steps.
serve.
Same prayer, Lordship. Let it come upon 9th, Lordship.
Lordship, can it
Get
be
the
before vacation, lordship? Can it be before vacation?
You are fixing it on 9th, coming Monday.
Monday.
Nah, nothing.
Oh.
Okay, obliged lordship.
Please, your lordship. Severe matter, my lord. Lord counsel is here, my lord. 61. My lord, will kindly come to page 37. I mean, in this case, your lordship, while granting bail to the co-accused, my lord, had observed that this is a case where the accused was arrested on 4/9/2024, and when the section 409 IPC was added, it was added on 4/11/2024, which was after the expiry of the 60 days. So, my lord, the petitioner before your lordships are also similarly situated. Both of them were arrested on 4/9, arrested and remanded on 4/9/2024. Section was added on 4/11, my lord. So the law which has been laid down by your lordship in page 37, my lord, that is also applicable to these petitioners. Lordship, let me clarify with regard to default bail. Correct, lordship. When he was arrested on 4/9/24, and 60 days was over by 2/11/24. And IPC was added on 4/11/24. And lordship, the petitioner of this order, he filed a petition prior to adding of the section. Therefore, default bail he is entitled. But after adding of this 409, lordship, he ought to have filed prior to this 4/11/2024. Here in this case, he has not. Therefore, this 90-day period will be counted from the first day of remand, lordship. That is on 4/9/24 till lordship 2/11/24. Therefore, he is not entitled for a default bail. And in this case, lordship, we have submitted the charge sheet on 30/11/24 before expiry of the 90-day period. Am I clear, lordship? Well, in response to that, my lord, the law which my learned friend is citing would emanate from Rakesh Paul, my lord. Correct. Because Rakesh Paul says that if there must be a bail application pending, or that bail application must be made when the default bail period expires. Now, that very Rakesh Paul also, my lord, lays on another duty. Duty is cast on the court, that as and when the 60-day period is over, or the default bail period is over, the court must intimate it to the accused that your default bail period is over and you are entitled to go on bail. If you are ready and willing to go on bail, you will be released on bail. Now, your lordship, the learned PP can enlighten the court, my lord, whether on 2/11/2024, when the 60-day period was over, whether I was informed that my 60-day, that my default bail period is over. Now, if the learned court below has faltered in intimating me about my right, my lord, then that right does not get defeated by subsequent adding of the section or subsequent filing of the charge sheet. So when Rakesh Paul is read, Rakesh Paul has to be read holistically, my lord, comprehensively. Both aspects have to be considered. This aspect, that whether there was a bail petition pending or not, as well as the fact that whether the duty which was cast on the court to intimate the accused that his right has accrued, that has also been complied with or not. When
did you file the bail application?
This bail application, my lord, was filed on 20th of November. 20 November, this bail application was filed before this honorable court.
Prior to that,
Prior to that, my lord, there was another bail application which we had filed on 11/11 before the trial court, my lord. So this aspect, my lord, the learned PP is submitting, that is fair on one point, but this other point is also to be considered by this honorable court as to whether when expiry I was informed of my right to default bail or not.
Just give us the citation of Rakesh.
Rakesh Paul, my lord.
Okay, we'll take it up. No problem. Okay,
My lord, I can give the citation now, or should we take it up tomorrow, my lord?
we'll take it up. Give it to him.
I'll give it to you.
We'll consider Monday.
Lordship.
Monday.
Monday. Highly.
I have a small prayer regarding item number 52, my lord. Can it be taken up on Monday? I have some urgency, my lord. Sir, regarding the relaxation of condition, my lord. Last 52, my lord. Can it be taken up Monday, my lord?
It has been listed why?
My lord.
His IA is there for what?
I is for my lord relaxation of the condition, my lord, because last 3 years, my lord, I have to appear every alternative 3 days before the police station, my lord. No search sheet has been submitted till today. Now I am a government official. Now, my lord, my transport is due, my lord. That's why only that condition. There is no departmental proceeding also.
Monday no, 11.
That's the only condition.
That other condition, my lord, I don't need any relaxation, but only this condition I relax.
That your personal appearance before the IO.
Every alternative 3 days, my lord. That is already 3 years elapsed, my lord. No search sheet has been submitted. I am a government official. Now, my lord, transfer is due, my lord.
That Mr. Sharma, do one thing in this particular item number 52.
52.
Get the information from the concerned IO that whether he is complying with the terms and conditions. If he is regularly complying with the terms and conditions, we will consider the prayer of the applicant.
Lordship, 52.
He was asked to appear before the concerned IO every alternate day.
Lordship.
But if in the period of 3 years after that order you have not filed the charge sheet,
Lordship.
maybe some reasons are there, we do not know why. But thing is, let us know by Monday. At least to that extent, you get the information.
Correct.
Consider Monday, but have the information. This has to come from which police station?
Boku, my lord. Come.
You can get that information.
Okay, the dim lagila.
Give him the police station case number and the
My
order
lord,
of bail copy.
definitely.
That's all sufficient.
Deep office. That is on Monday, my lord.
It will be on Monday. There are certain matters which have been given to us, 37, 38, 39, 41, 43 and 47, but there are CDs available. And which is the other one? In item 42, there is a scan copy. And
CD also there.
CD is there, Lordship.
CD is there.
okay, I think here. 64.
64 years.
These matters will come up on Monday. And these matters 37, 38, 39, 41, 42, 43, 47. As well as 64, we'll take it up immediately after the motion matter.
My lord, item 37 may be listed on 17, my lord. I will not available. 37, my lord.
Lordship, may I pray for item number 51, Lordship?
Mr. Agarwal, today from 3:30, we are having a division bench.
Lordship.
That is from Arunachal Pradesh again.
Yeah, Lordship.
That is the difficulty.
Now, Lordship, I am praying for item 51 on Monday, Lordship.
Just a minute. See, yes, you can ask me for Monday. If it is possible, we'll definitely consider a matter on Monday. Okay?
Obliged, Lordship. Thank you. Monday,
May it please your Lordship. As
Just take it.
yes, Lord.
Mr. Goswami, tell us.
My lord, transfer matter, I just received the file, my lord. Actually, I wanted some time to go through it. But I have seen, my lord, here, affidavit is already filed on behalf of.
No, we are here on the IA only.
Yes, my lord. So far as I am concerned, my lord, from the state, my lord.
Nothing happened. Yes, what do you have to say about the IA?
Well, as per the minutes of the meetings arrived between the parties, it seems the parties have already agreed. If as per the agreement, Malad, as for the agreement arrived between the parties, Malad, the especially respondent, the department here, BRO has already agreed with Malad to construct the road from the proposed Malad, so as to Malad, it can be a Malad defense land, defense purpose also, Malad. So, Malad, once the Malad, the agreement has already entered into between the parties by way of this minus Malad.
Where is that page?
Page number 9 of the IEA, Malad. Sorry, additional affidavit, I'm sorry.
We had filed an additional affidavit on 4/11/2024.
Particularly ballot page number 9.
Before that, may I just clarify the development that has happened after the matter was CAV? So what had happened was, as Lordship had heard the matter and the matter was kept for reserve for judgment, the BRO tried to initiate the entire activities for construction of road in that particular direction to which we had objected, and there was a status quo order applicable. So therefore, we had filed this IA, and in the IA, we were therefore we're bringing it before this honorable court the fact that they were deliberately violating the honorable court's order. But in the meantime, during the pendency of that IA itself, by way of an additional affidavit, we have brought that a meeting was conducted between the concerned aggrieved parties as well as the ministry and the BRO, and therein a minute was made up, and that minute, if your lordship will see, lordship has got the additional affidavit. If your lordship will come to page 7. Page 7 of the additional affidavit. This is dated 1st of November 2024. Forwarding of minutes of meeting dated 1/11/2024 for Taliha Tato Road. Now, if your lordship will kindly turn to page 9. Page 9, the conclusion or the decision that was taken. May I just read that, Lordship? Yes, Lord. Page 9, clause 8, small a is relevant. If your lordship may also see that map at page 11, just for an understanding. Now, this is basically a hand-drawn map just to indicate certain things as to how this road was supposed to be constructed and what has now been agreed upon. If your lordship will see the left-hand side corner, left-hand side bottom, this is Taliha Tato 0 point. The lordship is there, the map, page 11. Just to indicate as to what this minute would otherwise mean in reality. Page 11 of the additional affidavit. Now, lordship will see at the left-hand side, bottom, there is one road entering. This is called the Taliha Tato 0 point, and there is a bridge called Kazina Bridge. Lordship has seen that? Now, towards the left is the road that was proposed to be constructed by the BRO. That is through this Sisi Seki Bridge, and this is through the Payang Circle. And it ultimately goes ahead and reaches Tato, that your lordship will see at the right-hand side top corner, Tato. Right-hand side top corner. So the entire road that was otherwise been supposed to be constructed is this road towards the left. We objected to this under various grounds. Lordship had considered that, and judgment was pending. Now, this minute, this therefore now also agrees that this road that is to the right-hand side will be constructed. And this is that from 0 point to Nimfu, connecting to that frontier highway, ultimately leading to Tato, the right-hand side road. So this now, by way of this minute, they are saying that yes, we will construct this alternate route. Our entire effort was to say that the route should have gone through the right-hand side. Now, though the BRO does not surrender to their earlier stand that they will not construct a road on the left-hand side, but the BRO has now said we will construct another alternate road by this side also, thereby giving two roads, and which is also essential because of this of defense purposes. If one road is closed sometimes, they can always use the second route. So therefore, I think now good sense has prevailed, and now they are saying that we will construct this road also to the right-hand side, touching Tato through the Nymphu way, the right-hand side road, Lordship. So if this understanding that has been now minuted, if this is brought on record and a Lordship observes that they should therefore act on this, then I do not think there will be any dispute otherwise remaining, Lordship. So this is what I wanted to place before Lordships. So if they are directed to act accordingly, because they are saying, because the minute otherwise says that we have to withdraw the PIL also. So our apprehension, to be very honest, Lordship, tomorrow after withdrawal, if they don't do it, the entire effort will be lost. So therefore, this may be recorded properly. That this is the minute, this is what the government has also, or the BRO has also agreed to, and they should therefore act accordingly, Lordship. That will therefore protect our interests. So this is my prayer before Lordship.
Now, already this right side road, PMGSY road is already there.
Right hand side, there was one single PM that now they are going for double laning, Lordship. And they will connect it to that frontier highway ultimately, giving two roads basically, therefore. So it was only a single lane till Nymphu. Now they will make double lane from 0 to Nymphu and then connect it to the frontier highway, ultimately leading to Tato, Lordship. So people will be benefited. There will be two roads. People from all sides will be able to get access to the road, Lordship. Public interest will be served accordingly. So this is our prayer, Lord. Maybe therefore an extensive judgment may not be required. If this is brought on record, matter can be amicably closed.
Mr. Kato, just tell us from the minutes that you will be going ahead with the road on the left at page 11 of the additional. But you also place a proposal before the government of India for double laning the existing PMGSY road, which is on the right.
Right.
That's correct?
Well.
To that extent.
Good man.
You'll place your proposal before the authority council.
My lord, earlier whole contention was this is the left side, my lord. Originally that approval is still stand, my lord.
No,
and some portion of the
we know.
yes,
That approval we know.
that was the whole contention, my lord. Now that this new proposal has come up by way of my lord.
This was, you have already proceeded with the road on the left side.
My lord.
From CC Vacated Bridge to
My lord.
Tato, right?
Tato, yes, doctor.
And it will go through that side of the CC River and other places.
My lord.
And then since there is an already existing PMGSY road, this PIL was filed that it should be double lane. And it can be also in that way also you can go to Tato.
It has to be connected from Nymphu.
Order of status quo path earlier.
Well,
that's what is happening.
Yes.
Okay. And agreement is that the that we will place a proposal for the authority concerned. At the same time, you will also develop the or will make it into double lane.
Double lane.
The existing PMGSY road, which
Because
is on the right side.
Because from Nymphu it is not connected. From Nymphu to that frontier highway it is not connected. That PMGSY road is only till Nymphu. From Nymphu to the frontier highway, that part
17 kilometers
is not connected. 17 kilometers. So that also they will have to do.
And the new cutting,
that was the understanding. New cutting.
New cutting is 17 kilometers from E to my lord, F, my lord.
That is why our arguments.
Is PMGSY then is only up to Nymphu.
Nymphu,
correct.
Yes.
And the demand is that from Nymphu to the proposed
correct
road, it has to be connected.
Frontier highway. So that is why our argument was at the initial stage that this road is already there. You can construct this road. Why go through a green field when you already have a road in the right hand side?
Okay.
But be that as it may, since they have now.
They want that 17 kilometers to be talked about. And for that purpose, they make a proposal.
It's ultimately a development thing only. It's benefiting everyone. It's not something that
only that 17 kilometers joining from Nipo to the.
Yes, by double lane lordship, that is
That
important.
is the new
double
cutting
lane.
only, my lord. The portion of lane.
And then there
to
will be two
executed
alternate
by way
routes.
of new cutting.
If something happens to the other route, they will always have an alternate route. And as the BRO was saying, this is for defense. Then why not have two roads? It's good for defense. The entire argument of BRO was this is a defense purpose road and therefore do not interfere with this.
Just Mr. Kato explained this.
My lord.
Come to page number 9.
Yes, my lord.
Para 8.
My lord.
Now, BRO and PWD will initiate a proposal for 2-lane in existing PMGCY road from 0.00 kilometer to Nimpu.
Correct, my lord.
Now, where is that one 0.00?
That is in the map, Lordship will see left hand side bottom. Taliha Tato 0 point. That Tajina bridge, that is the 0 point. Tajina bridge is the 0 point, Lordship. Left hand side bottom. This is known as a 0 point, and from there the road is measured.
BRO and PWD will initiate a proposal for 2-lane in existing PMJSY road from 100 kilometers to Nimpu, Malan. That is one aspect, Malan. That is already existing, Malan. And the same will be connecting to Talia Tato main road, Malan. 17 kilometers. That means, Malan. From Nimpu to, it will connect to, Malan, the main frontier highway, which
will
the
ultimately
distance of
connect
lane,
to Tato.
Malan, 17 kilometers. The fresh cutting is to be done for only this 17 kilometers. Rest are already existing, Malan.
Yes. That is why we always say that this is a more viable project on the right hand side rather than going by a greenfield area. This was our entire case, Lordship, from initial stage. Is your Lordship having a colored copy of the map?
Everything will be followed as per the rule.
I'm having a colored one, so I was just wondering. If I may just,
You can ask your colleague to make a colored photo state and give it.
I'll just place this only, Lordship, because this is more prominent.
No,
I am holding this and I'm feeling guilty.
Will be not, doesn't matter. Does not require.
No, it's okay.
We'll be needing 2 copies. That's the reason. Make a colored.
I will make 2 copies. Yes, Lordship. I'll do it now only.
Colored photo state and give it to the our vendor.
Yes, sir.
To consider it.
Approval লাগিব. Yes. This is only that we wanted to place, Lordship.
The petitioner, sorry, the applicant. Earlier filed APL being PIL 16 within bracket AP plus 2023, wherein judgment is awaited. During dependency of the said PIL, certain developments took place. Between the border road organization
Malan, represented by the chief engineer project Brahman.
represented by Project Oruna, And Petitioner Association. In presence of Chairman, in presence of the local MLA from
Honorable
State, Minister for Commerce and Industries,
Yes, trade, commerce. and-
in bracket industries, skill development and entrepreneurship, textile and handicrafts, trade and commerce and sericulture, bracket clothes, labor and employment, information, public relations and printing, State of Arunachal Pradesh. A petitioner association declared, namely associations. Silan Valley, SILN, Valley BLN, UI, People's Welfare Forum, and all Arunachal Pradesh Students Union. And in that figure, a minute was prepared by the authority concerned on 1/11/2024 in presence of the Chief Minister of the state, who is also the local MLA, relating to existing Talhiya Tato 0. PM Jeswai Road up to Nimpu village, as well as the proposed road from Mr. Kato, it will start from where, which is to be constructed. The road to be constructed.
Malad road to be constructed from Nimpu to
No, not that.
The existing
Other-
one,
no, not the existing road, the defense road.
the defense road would be from Taliha to
Because that
Tato
is not
via Payang Circle.
It will
left
start-
side, my lord.
No, that is from which side? From who?
From A to, my lord, A to up to Efru BRO road, my lord, by road by BRO, my lord. That is B junction, my lord. That is already proposed and initiated for the, my lord, the NIT, my lord.
They identify it as Taliha to Tato via Payang Circle.
Taliha to Tato
Via Payang Circle.
Payang Circle.
And our side
The
is
road
via Nimpu.
to be constructed by the BR.
Yeah. Proposed construction. Proposed.
To be constructed.
Yes,
Proposed to
but
be
it's still
constructed
not
by
there.
Proposed to be constructed by the BR.
Yes, sir.
Third, Mr. A. Sharma, Learned Counsel for the Petitioners Association. Mr. Abhidi Goswami, Learned Additional Advocate General, Arunachal Pradesh. The respondent number
1, 2, 3.
1, 2, 3.
1, 2, 3.
No.
Is it?
123. And Mr. M. Kato, Deputy Solicitor General of India. For
Respondent number 4, 5, 6, and 7.
10 and 11. 8 and 9 are not represented today. Doesn't matter.
Doesn't matter.
Take care of it.
You were the consultant only.
Let's along with depending PL 16 AP 202. It's its verdict. We'll take care of.
Yes, Lordship. So our humble request and prayer is to ensure that this minute is taken care of, Lordship. So this ultimately benefiting the state of Arunachal Pradesh as well as the public at large, Lordship. Oblige, Your Lordship.
Deeply obliged, my lord.
Sometime I'm just submitting this colored map.
Now you can give it to him.
Yes.
Yes.
Yes,
Give us 2 copies so that it can be treated.
yes, Lordship. We just make one more copy and submit. I already have one.
You can keep 1 copy. You can just from that you can make 2 copies.
I will do it, Lord.
There are
I'll-
colored photographs.
Yes, Lord.
Colored photo states are there.
Yeah. I just asked my junior whether this is Xerox or color. He says Xerox is there and I'm holding a colored.
You can make it colored.
Yes, Lordship. I'll just submit.
Deeply obliged.
Oblige, Your Lordship.